Hello and welcome to Senior Legal Services. My name is Karen McGuire and I'm a case manager for our consumer debt law practice, and I'm pleased to present our new monthly workshop series on consumer debt collection. This is the first of an ongoing series that we will be offering to help educate people about their rights when it comes to dealing with debt collectors, debt collection lawsuits, and Chapter 7 bankruptcy. The goal of today's workshop is to discuss your legal rights and options if you get sued by a debt collector. In addition to hosting monthly workshops about consumer debt, we are also now offering monthly in-person clinics at our Santa Cruz office to help seniors who are facing legal problems as a result of the COVID-19 pandemic. If you are 60 or older and you are having debt problems due to COVID, please contact our office to make an appointment. Our services are completely free of charge, and all of our contact information can be found on the last slide of this presentation. First, I'd like to share a little bit of information about our organization. We were founded over 50 years ago, and our mission is to provide free legal services to seniors aged 60 or older in Santa Cruz and San Benito counties. We have a team of attorneys, paralegals, and legal advocates that handle a broad range of legal problems related to housing, public benefits, fraud, elder abuse, and consumer debt. Moving on to the main focus of this webinar, I'll begin by providing an overview of some of the legal options that are available to you if you get sued for personal debt. Getting sued can be very stressful, and many people just don't know what to do or how to respond. If a debt collector files a lawsuit against you to collect a personal debt, you have several legal options available to you, including you can respond to the lawsuit and then show up to court by a deadline listed in your court papers, regardless of whether you think you owe the debt or not. You can choose not to respond to the lawsuit. You can settle, or you can file for Chapter 7 bankruptcy. Generally, it is important to respond to the lawsuit by filing an answer, either yourself or through an attorney, in order to preserve your rights. If you choose to respond, you have to make sure you do it within the deadline, and you have to decide how you're going to respond. By responding to the lawsuit, either through yourself or through an attorney, you can make sure that the collector has to prove that you owe the debt, that the amount of the debt is correct, and the debt collector has the legal right to sue you to collect on it. You may be able to resolve the debt by responding or showing up in court, because some collectors would rather settle than go through extended litigation. Although it is listed as an option here, we advise you not to ignore the lawsuit even if you don't think you owe the debt. Responding to a debt collector's lawsuit in court will likely put you in a better situation, cost you less in fees, and give you more control over how you repay the debt. You have 30 days after the date you were served to file a response with the court. It's important to note that the 30 days includes weekend days and court holidays. If the last day falls on a day that the court is closed, then you have until the next day that the court is open. If you do not file an answer on time, the debt collector can get a default judgment against you, which, if granted, will allow them to enforce the full amount they are suing you for with the power of the court behind them. Ultimately, only you can decide if it's in your best interest to respond to the lawsuit or not. Now let's talk about the option of not responding to the lawsuit. Ignoring the legal notices and papers won't make the lawsuit go away. And despite what you may have seen in TV shows, you can't stop things by refusing to accept delivery or service of the lawsuit. In fact, the case can go ahead without you. That means that the court can rule without hearing your side, and the debt collector could win by default because you didn't show up. If the court rules against you and orders you to pay the debt collector may be able to garnish or take money from your wages or bank account, or even put a lien on your property like your home. The debt collector can also ask the court to award them additional money for collection costs, interest, and even attorney's fees. And the consequences vary state by state. In California, judgments last for at least 10 years and are renewable. They also incur a 10% simple interest every year. Debt collectors can garnish your wages, take money out of your bank account, and put levies on your property. Now, you may want to choose this option if you are judgment-proof, meaning you have no assets to take and you have no defenses. A judgment can also show up on your credit report, and it might make it harder to get credit in the future, which can then affect whether you can get a job, insurance, a cell phone, or purchase a home. Your next legal option might be to settle your debt. Since debt collectors would prefer to receive their money without having to take legal action, typically the best way to avoid a lawsuit is to communicate with the collector. The goal would be to assure the collector that you intend to repay the debt or let the company know that you can't pay the debt at all. If you want to try and settle, make sure that you can actually pay what you were offering. Otherwise, you may end up in a worse situation than you are in now. Whatever agreement you come to, ask the creditor to put it in writing and dismiss the case, and make sure you receive a copy of that letter. And even if you do reach an agreement with the creditor, you must still file an answer and show up to the court hearing unless the other party files to dismiss the case. If you have income or financial assets that a court could order to be taken to satisfy the debt, you might be better off working out a voluntary repayment plan or a settlement. A settlement means that you would pay less than the full balance, but the debt would be considered paid in full. But again, this is a crucial decision that is better made with the counsel of an experienced credit counseling agency or a debt collection attorney. And when discussing repayment options, the collector may pressure you to provide immediate payment in full, but you should review your finances before committing to anything. The collector might be quicker to sue you if you miss agreed upon payments. Explain any circumstances that affect your ability to pay, and if necessary, make an appointment for a follow-up call. And reschedule if you can't make it, because being a no-show will hurt you. Another option to consider if your debt is too large to pay and you don't see any way out is bankruptcy, either before or after you're sued. Chapter 7 bankruptcy does a great job of stopping creditors and wiping out qualifying debts like credit card balances, medical and utility bills, unpaid rent and lease payments, personal loans, and more. But some types of problems require quick action, legal knowledge, and experience. A collector cannot continue collecting on an account while the court is considering a bankruptcy case, and it cannot try to collect on a debt that has been discharged in bankruptcy. The fear of losing the ability to collect on any part of money owed because of bankruptcy sometimes makes collectors more amenable to repayment plans or settlement proposals. Some of the debts that you would be able to discharge include credit card balances, car loans, if you planned on letting go of the car, medical bills, past due rent, utility bills, deficiency judgments after repossession, payday and other personal loans, and money owed on leases and contracts like gym memberships. You don't need a certain amount of debt to file for Chapter 7, but filing for bankruptcy will negatively affect your credit score for up to 10 years, and you're only entitled to a Chapter 7 bank discharge once every 8 years. If you incurred your debt as a result of the COVID-19 pandemic, Senior Legal can help you file for Chapter 7 bankruptcy. Please contact our office to make an appointment or call us for more information. Some debts, called non-dischargeable debts, cannot be wiped out in bankruptcy, and non-dischargeable debt rules get confusing quickly. For example, you cannot discharge spousal or child support arrearages in bankruptcy. You will remain responsible for them after the case. DUI and fraud-related debts also are not dischargeable if a creditor objects. Marital property settlement obligations and tax debt paid with a credit card also are not dischargeable in Chapter 7, but they are dischargeable in Chapter 13. And liens against your property don't go away in bankruptcy except in particular circumstances. It's important to be aware that not everyone is entitled to a Chapter 7 discharge. You have to prove that either your household gross income is below a certain amount, or you don't have enough money to make reasonable creditor payments through a Chapter 13 repayment plan. If you are married, two people can file Chapter 7 together, but it's a bit more complicated even if only one spouse files. For instance, did you realize that a married person can file alone but must disclose the non-filing spouse's income? But if they're living apart, they can claim expenses for two households. So that's just the tip of the iceberg. It's good. It's a good idea to let a lawyer help you work through these details. And if you don't have any of the problems I've discussed above, your case is simply ready to file without a lawyer. But other issues can exist, and sometimes you need to file for bankruptcy fast. So it's a good idea to get legal advice before deciding to take the do-it-yourself approach. And as I mentioned, if you incurred your debt as a result of the COVID-19 pandemic, we can help you file for Chapter 7 bankruptcy for free. So please call our office to make an appointment. Now moving on to the last legal option in this webinar, which is answering the lawsuit. By responding to the lawsuit, either yourself or through an attorney, you can make sure that the collector has to prove that you owe the debt, that the amount of the debt is correct, that the debt collector has the legal right to sue you to collect on it. You may even be able to resolve the debt by responding or showing up in court, because some collectors would rather settle than going through extended litigation. Once you decide you're going to respond to the lawsuit, remember you must respond within 30 days from the date you were served on the lawsuit. About the deadline. If you are not sure how you were served with the complaint, look at the proof of service of summons in your case. Complete the filing and service of your answer before the 30 days from the time you were served if you were served personally, or 40 days if you were served by mail or someone else in the household, called substituted service, based on the information in the proof of service of summons and complaint. So to summarize what I just discussed, the main steps to take if you get sued by a debt collector are: 1, answering the lawsuit, which you may have to do in writing or by showing up to court or both. The papers that say the debt collector is suing you will tell you what to do. 2, looking over your records about the debt and any information you may have gotten from the collector, including the validation information that debt collectors must send you. And 3, spotting any issues with the lawsuit. It's the collector's responsibility to prove the lawsuit claims. They must prove that you are the person who owes the debt, that the debt amount is accurate, including any interest or fees, and that you owe the debt to them and not to someone else. And if the debt is old, you need to make sure that the time for the collector to sue has not already expired. You may also respond to the lawsuit by filing a motion or a request that tells the court that the plaintiff made a mistake in the lawsuit. In California, depending on the judge in your case, the case may last anywhere from 6 months to a year and a half. It is extremely important to check your mailbox daily and open your mail as soon as you receive it, because many of the documents you may receive in the case are time sensitive, and failing to act in time may result in permanently hurting your case. So open your documents immediately so that you have enough time to find legal help if you need it. Now let's talk about old debt. Debt doesn't usually go away, but debt collectors do have a limited amount of time to sue you to collect on a debt. This time period is called statute of limitations, and it usually starts when you miss a payment on a debt. After the statute of limitations run, your unpaid debt is considered time barred. In California, there is a 4-year limit for filing a lawsuit to collect a debt based on a written agreement. Now, can a debt collector sue you about a time barred debt? If the debt is indeed time barred, it is against the law for a debt collector to sue you for not paying it. If you do get sued for a time barred debt, tell the judge that the statute of limitations has run out. Now, can a debt collector contact you about a time barred debt? Even though debt collectors may not be able to sue you to collect an old debt, they may still be able to send you collection notices, call you to try and get you to pay, or report your debt to credit reporting agencies. If you don't pay your bills for a consumer debt, like your credit card or a cell phone, or if you fail to make payments on a personal loan or medical bills, the creditor can sue you for a debt they claim you owe. Once the creditor gets a money judgment against you, it can garnish certain kinds of income. The creditor collector may be allowed to seize the collateral for a secured debt without going to court. For example, repossess the car you purchased with an unpaid car loan. Whether the creditor collector who wins a judgment against you can garnish your wages or seize your bank account, and how much can be taken, will depend on things like the amount and source of your income. However, if your only source of income comes from government benefits, you will most likely be considered judgment proof, and your income will be protected from being garnished or seized if you have a judgment against you. Now let's talk about what it means to be judgment proof. I've mentioned this term earlier in the webinar, and the term judgment proof is a term that refers to a consumer who has defaulted on his or her debts and does not have the level of income or assets that could be seized under the law for repayment of that debt. In other words, if you have no income or assets, there's nothing to collect against a judgment won by a creditor in a lawsuit. Being judgment proof does not prevent a creditor or debt collector from filing a lawsuit or winning a judgment against you, but there may be nothing available for the creditor to collect towards satisfying that debt. And for this reason, you may not want to respond to the lawsuit if you are truly judgment proof. If your only source of income is government benefits, these benefits may be protected from being garnished or seized if you have a judgment against you. In some cases, these benefits can't be touched at all, while in other cases, they could be garnished to some degree to pay certain types of debts, such as child support, alimony, student loans, and delinquent taxes. The listed benefits that are protected include Social Security benefits, supplemental security income benefits, veterans benefits, federal student aid, military annuities and survivors benefits, benefits from the Office of Personnel Management, railroad retirement benefits, and federal emergency disaster assistance. To summarize what I've discussed so far, if a debt collector files a lawsuit against you to collect a debt, most often it is important to respond, either yourself or through an attorney. And always remember, you have rights when it comes to dealing with debt collectors. This concludes today's presentation. If you have been sued or if you have questions about your debt or whether filing Chapter 7 bankruptcy is right for you, please give our office a call to make an appointment. Thank you for watching.